multidisciplinary practices within the NHS, but you can't have multidisciplinary practices within legal services, accountants and all that. So how exactly does your analogy work?
It was really just an analogy based in England, not Scotland. I mean, we're a UK union, and we have vast experience of the opening up of the NHS to privatisation. And what we have seen is that areas and parts of the sector that have been opened up to privatisation, that the very attractive and what has been seen as money-spinning areas have been creamed off and have been the ones that have been taken up by private enterprise, by social enterprise and by outsourcing.
The point I was really making was that what we seem to be creating here is not a kind of mirror image of what's happened to the NHS in England in terms of opening up privatisation, but a change in structures, so that, because I mean all these firms are private. I mean they're not public firms. They're not public sector. All the firms of accountants and lawyers are in the private sector. So what I'm trying to understand is how a bill that breaks down the barriers between different professionals is analogous to the privatisation of the health service in England.
I think it's about the overall control of legal services and the fact that, as a trade union, we don't want to see that being wholly controlled by the private sector.
As I said, I mean, could you name a public sector legal firm or accountant?
I'm not saying that it's run by the public sector, but there's the government input into the legal system. There's the monitoring, the accountability. That's all part of government at this moment in time. What we don't want to see is for that to be wholly controlled by the private sector.
I'm interested in your phrase "wholly controlled by the private sector." Again, I fail to understand what that really means. You've accepted, I think, that at the moment these are private firms, although I accept your point about the government role in this, although I would say that there seems to be clear from the bill and other evidence that there is also government control, I wouldn't use that phrase myself, but monitoring by ministers after, if this bill was passed. So could you explain what you mean by wholly privately controlled?
I think one of our concerns is that it's not exactly clear from the bill what the control and what the monitoring, what the accountability will be in the future, and I think that kind of outlines some of our areas of concern.
Well, I'll leave that just now, Convener. I think maybe others may want to come on this.
Cathy Craigie wants to follow that up.
Thank you, Convener. Fiona, I'm having a look through at the submission here. Is your concern that if this bill were to go through, that it would create an open door for people to come in for purely profit, rather than the provision of legal services? Being motivated with the profit aspect of it?
Yes. Yeah, I mean, that is our concern, that the motivation would be profit, and what you would end up would be a very unequal justice system. There would be inequality, and only those that could afford to access the system would be able to do so, not necessarily those that had the most demanding or the most pertinent cases.
I was going to leave it, but again, I'm failing to understand your line of argument. The question was, about that legal firms would be out for profit. Could you explain to me, in the current setup, legal firms, which are private enterprises, we've already established that, who are not out for profit? I mean, I'm
not saying that legal firms are not out for profit. They are within the private sector. My concern is that by allowing in the multinationals, the banks and the supermarkets, you're opening it up to something completely different, and the accountability and the whole control issue would be a real concern for us, because we have seen that, as I've outlined earlier, within the NHS, when that's been opened up to social enterprise, to multinationals, we've seen the fallout from that.
I really fail to understand your argument, to be honest here. I don't want to be rude, but I mean, frankly, we've got a situation at the moment where legal firms, accountancy firms, all the people who would be involved in this bill effectively are small, sometimes one person, right up to very large organisations, not multidisciplinary, but single services, which are profit-seeking. I mean, they are businesses which seek to survive and generate profit for their members. I don't understand the difference that you're trying to establish from what happens now to these firms, perhaps owned by the same people, perhaps owned by different people, would still be out to make a profit. I mean, I frankly can't see the difference.
I think we've outlined it quite clearly in our case, and I've outlined it a number of times today. I'm not quite sure what else I can say to explain it further to you.
Yes, so it's up to us to make an assessment of it. Could you carry on with regard to the independence aspect?
Certainly, Convener. Can I move on then in terms of the regulatory role for Scottish ministers, which we've just touched upon very briefly? Do either of you believe that, that this particular role is consistent with the independence of the judiciary and the independence of the legal profession, I should say? Sarah.
Perhaps I could say, I mean, we are very keen on the idea of an advisory panel for ministers to advise them on the regulatory framework, and we think that would deal with a lot of these concerns.
How would that do that? I mean, how would this panel be selected? Who would be on this panel?
Well, that's something we don't know. I mean, clearly at the moment there's nothing in the bill about having it in the legislation, which we're very disappointed by, because the majority of respondees to the consultation wanted to see that. And we know from the policy memorandum that the Scottish Government does intend to establish it, but not on a statutory footing. And we think it should be on a statutory footing. And clearly the composition would be something that would need to be looked at. But we'd certainly like to see very strong consumer representation on it.
Ms Farmer?
We would be more supportive of a legal commission. Again, how that would actually be structured, we haven't put any sort of figures or any real meat on the bones of that, but that would certainly be the way that we would like to see it going forward.
So what would be the difference between a legal commission and the panel that we've just been discussing, just for clarity's sake?
I think in terms of accountability, a commission, it would be more in the accountability area.
Okay. It's been suggested by some of the evidence we've received that perhaps, for example, an enhanced role for the Lord President could deal with the issue of this perceived, if it is that, independence question. Do you think that's sufficient? Either of you?
We think it's entirely proper that the Lord President should be consulted on these issues, but we do have concerns about the suggestion that his approval or her approval should be required for a number of reasons, because it's not clear how that sits with some of the Lord President's other roles, both as a member of the Faculty of Advocates and as head of the Scottish Court Service. And we would also have concerns about anyone applying to be approved regulator who are not a legal professional body, because it could be public perception may say, well, why is the Lord President involved in this? It's not just legal professional organisations who may be applying to be a regulator.
Are you suggesting there's a potential conflict of interest with the Lord President then?
We're suggesting there's certainly an issue of public perception there, potentially.
Okay. Ms Farmer, do you?
That's exactly what the point I would have made. We would have concerns about a potential conflict of interest if that were to be the only individual, yes.
So would you both agree that the Lord President should have a role, but he shouldn't have the approval of... Is that what you're saying? Is there some sort of halfway house you're talking about here, where he should have a role in it, some sort of advisory role, as opposed to the role that's being suggested?
What we have in the bill as it stands, yes. and we're quite happy with that, because clearly the Lord President has a very important role, particularly in relation to the legal issues.
Okay.
Yeah, participatory role, but not a governing role.
Okay.
Yes.
Thank you.
James Kelly will now pursue the question of regulation.
Thanks a lot, Convener. Just in terms of regulation, obviously what the bill seeks to do is to, as we've just been discussing, is to open up the legal profession, and you would therefore have traditional firms and also licensed legal service providers. And also on the regulation side, you would have approved regulators and existing regulators. How do you feel the bill, or do you feel the bill does enough to provide a level playing field in terms of regulatory burden, between traditional firms and, the kind of new setup of licensed legal service providers?
We have some concerns. I mean, we're very happy with the regulatory scheme in principle that's set out in the bill, but we have expressed concerns that those will not apply to traditional forms of practice. We think